Good afternoon. This is an oral argument on the petition of Bernard Young and the Division of Enforcement for review of the initial decision of an administrative law judge. A total of 40 minutes has been allowed for the argument, with 20 minutes allocated to each side. Respondent will argue first and may reserve time for rebuttal. Mr. Young, do you wish to reserve time for rebuttal?
Yes, ma'am, I do.
How much time? Okay, very good. You may proceed.
Good afternoon. Thank you for the opportunity to be here today. I'm not an attorney, but a regulator by training, and as such have the utmost respect for the Commission, having worked with you hand in hand for over 19 years. I'm not here today to argue the law because the staff has much more experience in that area than I, but I'm here to speak to you as a layman regarding the law and issues raised by this case for CCOs and what I believe the ramifications of the initial decision are should you allow it to stand. As human beings, sometimes the wrong cases are brought for the wrong reasons. The case before you today is one such instance. The first area I'd like to address in my remarks have already been made part of the record. In this regard, I believe it is important to state that I believe, based upon the Supreme Court decision in Gabelli v. SEC, which decision was issued February 2013, that the initial decision should be set aside in its entirety as the statute of limitations ran out prior to the staff's issuance of the OIP in August of 2012. The Supreme Court's decision specifically states there are good reasons why the fraud discovery rule has not been extended to government civil penalty enforcement actions. The SEC's very purpose, for example, is to root out fraud, and it has many legal tools at its hand to aid in that pursuit. Thus, the Court held that the 5-year clock begins when the fraud occurs, not when it's discovered. The Court's decision in Gabelli is relevant to this case in that a letter dated June 9, 2005, a copy of which has been provided to you, written by the SEC staff to the Antiguan banking regulators, requested certain information stated in part. This matter involves a suspected fraudulent scheme through the sale of unregistered securities by Stanford International Bank by and through Stanford Group Company. The letter further states, this matter involves a possible Ponzi scheme by SIB and goes into details about the possible misrepresentations and omissions in the offering materials. These offering materials and the revised versions, which were reviewed by both the SEC and FINRA numerous times prior to the staff's June 2005 letter, and were again provided to the regulators during my watch, are a centerpiece of the staff's case against me. As a side note, the marketing brochure was vetted by FINRA at their request, as they believed it constituted marketing materials, even though the CD was sold pursuant to Regulation D. It should be further noted that the staff has determined that the language that is misleading was in both the prior and the vetted FINRA versions of the brochure. The staff's 2000 letter to Antigua goes on to further detail the staff's concerns regarding the nature of the assets which compromised the SIB investment portfolio, the bank secrecy laws of Antigua, SIB's recurring annual 3% and referral payment, the audited financial statements of SIB, the use of sales contests, all of which formed the basis for the staff's case against me over 7 years later. As a layman reading the Gabelli decision, it sure looks like the 5-year statute of limitations began tolling no later than June 9, 2005, which, by the way, was more than a year before I joined Stanford Financial Group. As you are aware, I was not welsed until June 2010, and the OIP was not issued until August of 2012, a full 7 years after the staff sent the letter to Antigua. Judge Folak in her decision stated, during the fall of 2008, each respondent knew that SIB had a liquidity problem, and each was complicit in material misrepresentations and omissions designed to lull customers so as to forestall redemptions and continue sales of the SIB CD. Now, for the rest of the story. As unrebutted testimony, I met with a highest-ranking Antiguan regulator, Ms. White's, Chairman White's counterpart, who is responsible for oversight of SIB, in December 2008. As the DOJ evidence would later show, and unbeknownst to me, the regulator I met with received another bribe from Mr. Stanford 2 days after my meeting with him. In my final brief filed January 6, 2014, I reiterated my discussion with Mr. King, who told me that Stanford was one of the safest banks on the island and walked me through his agency's examination and review processes. The staff, and in turn the ALJ, mischaracterized the intent of what they called my roadshow as a ploy by me to convey, quote, the message that SIB was sound, unquote, when in fact a review of the first few slides of the presentation show that I simply discussed what my due diligence efforts were and the processes I used. I also shared what had been represented to me during my recent conversation with the Antiguan regulator. Yet in spite of this testimony, every instance of a material misrepresentation or omission cited in the initial decision took place after my conversation with Mr. King, and yet I was found to have willfully violated the rules. It is apparent that the staff's position in that making decisions about the proper course of conduct, I was not entitled to rely on the following: the information I received from the regulator in Antigua about the soundness of the bank and the Antiguan privacy laws, FINRA and their letter stating that the revised marketing brochure appeared to comply with advertising regulations and, as previously noted, contained the exact language the staff is now stating is misleading. In addition, at no time did FINRA question the insurance disclosures or require any clarifications in the brochure they approved as meeting advertising guidelines. Yes, the staff also does not want me to rely on the representations of the auditor, who was annually vetted not only by the Antiguan regulator but by the Eastern Caribbean Central Bank as to his competence and the financial statements he provided. I'm also not allowed to rely on two conversations with independent members of the bank's board, one of whom was a former chairman of the Central Bank of Barbados, and another of whom was a justice on the Eastern Caribbean Court of Appeals, a former justice. I'm not allowed to rely on outside legal counsel with more than 16 years' experience as an SEC enforcement official and another 10 years at the DOJ. I'm not allowed to rely on anyone at the bank, including the president or its chief compliance officer. I'm not allowed to rely on Stanford's own global chief compliance officer, who had been in my position previously and who had been one of Stanford's closest advisors since '96, and who was, by the way, continually registered with Stanford as a Series 24 from 1996 until the SEC's raid, and continues registered as with an investment advisor as a CCO today. I'm not allowed to rely on other chief compliance officers who served before me, looking at their documents or talking to them. And I'm certainly not allowed to rely on the Gang of Five, who have either served or are currently serving time in prison. It's important to note that the SEC has not even taken the depositions of any of the prior CCOs, Stanford's global chief compliance officer, or the president and CCO of the bank, all of whom are U.S. citizens with primary residences in the U.S. and Puerto Rico. The last area I want to address is one of due process that is afforded under the Commission's ALJ process. Due process requires that the procedures by which laws are applied must be even-handed so that individuals are not subjected to the arbitrary exercise of government power. In a typical enforcement hearing, the respondent is in possession of their records, including electronic, hard copy, and handwritten notes that can be used in order to prepare their defense. As you know, in February 2009, the SEC raided the Stanford offices and a receiver was appointed. The receiver took possession of all Stanford assets and corporate records, including my files and the compliance department's files. While it is true that shortly before the raid, I copied the hard drive of my travel computer onto a flash drive, it should be noted that the copy was made, as was my normal practice, to ensure that all documents on the traveling laptop were also contained on my office laptop, which was backed up regularly by the Stanford IT department. Thus, the purpose of the backup was to ensure compliance with the various SEC and FINRA rules relating to books and records. What was contained on the flash drive was a limited amount of information. It was in no way the totality of my files or my department's files. When the case was brought in the ALJ process, the staff knew that I had not seen my original documents, nor had I had access to them since the receiver stepped in. While it is true that the staff provided me with numerous documents of their choosing in preparation for the case, in spite of my requests, I to this day have never been provided with full copies of or access to my records or my department's records, specifically but not limited to handwritten notes, complete set of and a complete set of my SIB due diligence binders. Since I was specifically denied access to those documents, which were maintained under the receiver's control at a warehouse, I have no way of determining what else the staff may have withheld, which would have aided my defense. I have no idea what other documents are out there that I haven't been provided because I haven't been allowed access to them. Finally, while it is true that my representative was allowed limited access to the receiver's warehouse, this would be akin to me reviewing Chair White's files and trying to determine which ones were or were not important to her. I reserve the remainder of my time for rebuttal. Thank you.
Thank you. Mr. Reese, you may proceed.
Good afternoon, Commissioners. David Reese, today on behalf of the Division of Enforcement. I want to thank you as well for the opportunity to be here and talk about this important case. Commissioners, this case involves what Mr. Young did and what he didn't do during his time at SGC, Stanford Group Company, which was the wholly owned investment advisor and broker-dealer of Robert Allen Stanford. The record shows, and we all know probably at this point, that SGC was a primary vehicle that Mr. Stanford used to market his CD. But having said that, let me tell about two things this case is not about. The first is something that Mr. Young focused a lot in his papers about, and that is this is some sort of hindsight justice seeking to hold him as a scapegoat for the Ponzi scheme that Mr. Stanford perpetrated. That's not what this case is about. Once again, this case is about what Mr. Young did and what he didn't do and how that fell far short of his responsibilities under the securities laws. The second thing it's not about, and it's what he led with today, is because it's not an action brought against him because he's a compliance officer. This case is about his conduct, not his title. And in fact, it's Mr. Young who's trying to shield himself from liability by hiding behind his title. Now let's talk about what Mr. Young did and didn't do back during his time at SGC. At the outset, let me address the statute of limitations argument. I don't believe it has any bearing to this case. This case involves his conduct, which began in 2006 and continued onward into 2009. And in fact, much of the key conduct occurred in 2008 and 2009, well within the 5-year statute of limitations. So I don't think that's worth dwelling on, though I'm happy to address it further if the Commission would like. The second thing I want to address is the point that Mr. Young made about reliance. And I'll talk more about that in detail, but I want to talk about it in conjunction with the due process argument as well, just to briefly address those. Mr. Young was given every benefit of the doubt in the administrative proceeding conducted by Administrative Law Judge Folak. Any piece of evidence that the respondents wanted to admit was admitted and considered by the judge, including like one of the key pieces of evidence in this case that was admitted in their case to support their reliance arguments was simply a complaint drafted by third parties in a separate lawsuit, and that was admitted by them to show the role that the attorneys played. There was very little direct testimony on that issue. Nevertheless, as is clear from the initial decision, Judge Folak gave credit to the argument that Mr. Young asserted that he was allowed to assume that outside professionals looked at these documents and blessed them. But she also found, rightly so, that despite that, his conduct crossed over a line and went into conduct that caused SGC to violate 206(2) of the Advisors Act, and then his individual actions violated the scienter-based anti-fraud provisions and related statutes of the securities laws. I want to talk generally about why that decision is more than supported in the record. And in fact, Mr. Young could have been, I think, under this record found to be even more culpable than he was. While even if you credit the idea that he could rely and could assume that outside lawyers who were not disinterested, by the way, they were lawyers retained by the issuer that was also owned by Robert Allen Stanford. But even if you assume that he was allowed to assume that they had looked at these documents, the information and facts that he knew made it at least unreasonable and, in fact, in the division's view, reckless to continue doing what he did. And now I want to talk briefly about what he did and what he knew during his time there. I know I keep promising that, but I'm going to do it now. Mr. Young joined SGC in 2006 as its chief compliance officer, and then in 2007 assumed the role of due diligence officer. So in those roles, it was Mr. Young's job to determine whether to authorize SGC's financial advisors to market the SIB CD and also to conduct due diligence on it. He also helped conduct training, and this training was done hand in hand with the sales trainers as well. And that training consisted of nothing more than parroting the same language that came from SIB, and in fact was misleading in several regards, particularly with regard to the level of insurance that applied to the product. When Mr. Young walked in the door at SGC, he knew several things that are relevant to his in evaluating his conduct later. First, he knew that SGC was financially dependent on SIB, and that the SIB CD was SIB's only real substantive product. He also knew that the SIB CD was marketed as being supported by a well-diversified portfolio. But at the same time, and he knew that was relevant, he knew it was important to look into what the portfolio of the CD was, because he asked about it as part of his due diligence. But then he was told very clearly, you're not going to get access to that information. No one at SGC can know what's in that portfolio. He also knew, as soon as he walked in the door shortly thereafter, that SGC focused heavily on the CD. It had sales contests that were limited to the CD. It had top performers clubs that were limited to the CD. It had a trailing commission that, as Mr. Young later learned from an outside consultant, was clearly outsized and put an undue emphasis on selling the CD. And at that point, there's at least one thing Mr. Young could have easily done, well within his discretion, well within his authority, and that is at least ask, why does an SGC require its financial advisors to disclose to its clients that SGC does not know what's in that portfolio, and in fact will never know what's in that portfolio? And at trial, that became relevant because investors testified that they believed, reasonably so, that by being marketed by this U.S. investment advisor, broker-dealer, this offshore product, they assumed that the U.S. entity understood what they were selling them. But as Mr. Young knew, that's simply not true. They simply knew what SIB claimed about the product.
Mr. Reese, if I just stop you for 1 second on the, I should have asked it a moment ago, but the due diligence officer position, is that something that the prior CCO had also occupied?
Yes. And so, Commissioners, in some respects, even if the story ended there, ALJ Folek's decision would be well supported by the record. But the story certainly doesn't end there. What Mr. Young didn't talk about is the various other facts he knew. For example, Mr. Young had actual knowledge that while SIB claimed its portfolio was diversified in stocks, bonds, liquid securities, he knew, because he received reports documenting it, that SIB was also had significant investments in risky private equity, the antithesis of the type of investment that SIB was promising its investors was backing up the CD. Later, Mr. Young also knew that an outside firm that was examining a different product, a due diligence firm that had brought in to examine a different proprietary product that SGC was considering marketing, the first question they asked was, what's behind that proprietary product? How does it work? They couldn't get that information either. And they determined that if you can't get that information with this type of proprietary product, then you can't market it. And that was conveyed. Ultimately, that product was not marketed for a variety of reasons. But the important thing here is that Mr. Young knew that's how that due diligence consultant approached this type of issue, knew that was how the law required that consultant to approach this issue. Now, that wasn't about the SIB CD, but in fact, that only reinforces how important it was. That product was about, that consultant was examining a product that would be much less important to SGC than the SIB CD was, which was its bread and butter, and was increasingly becoming more of its bread and butter. But even with that, Mr. Young didn't do anything else other than simply blindly accept what SIB was telling him about the portfolio. He also knew that Pershing, the clearing broker for SGC, had been increasingly expressing concerns about the lack of transparency in the portfolio. And ultimately, as I'll get to in a minute, ultimately Pershing withdraws as being the clearing broker for that very reason, and Mr. Young, along with two other executives, sends an email to the FAs giving a false reason for that resignation. But right now, I'm just focused on the fact that he was aware of the transparency concerns that Pershing had. And yet again, no change in his action. And in fact, as we'll get to in a minute, he gets even more aggressive in his championing of SIB and the SIB CD. He also knew about client concerns, investors and potential investors, who, one of which was a CPA, wrote an email that Mr. Young saw and was aware of that explicitly said, based on the financials of SIB, this may be a Ponzi scheme. Again, this is not to say Mr. Young should have known this was a Ponzi scheme, but a reasonable person, and in fact, not doing so would be reckless in the division's view, at that point, should be asking some important questions before continuing to allow SGC's financial advisors to market this product based on those representations. And instead of that, all Mr. Young did was join in the effort by other executives to what they were describing as attacking those concerns. And that attack consisted of regurgitating, repackaging the same talking points that had been being given out routinely from their marketing materials. It wasn't an investigation into, hey, how can we actually determine what's going on here and tell these people that they're wrong? It was simply looking back at the materials, repackaging it to make it sound persuasive, and getting it out the door. That was the approach that Mr. Young not only knew about, participated in. And that brings us towards the end of the time of his tenure at SGC in late 2008 and 2009, as the scheme is beginning to unravel. And at that point, Mr. Young joins other sales executives and goes on what was called a roadshow. And Mr. Young tried to downplay it during his argument, but in fact, that roadshow was exactly what the witnesses testified as to what it was. That was an effort to reassure people that the bank was safe because they were having a run on the bank and they needed to stop the redemptions. And so they went to reassure people, and Mr. Young was a key part of that by basically vouching for the bank based on his work, when in fact he knew he had never learned anything about the bank. And then likewise, when Pershing withdrew, as I mentioned before, Mr. Young joined an email to the rest of the groups which falsely said that Pershing was withdrawing for tax-related reasons, when in fact, as Ed Zelazin, who was a Pershing employee who interacted with Mr. Young frequently, testified, he had told Mr. Young quite clearly about the transparency concerns, and it was clear to him from those conversations that Mr. Young understood the issue. As far as the reliance on the outside professionals, that has no place in this case for the simple reason that that reliance is unreasonable given the knowledge that Mr. Young had. Perhaps when he started at SGC, that reliance might have been reasonable. That's, in some ways, that's how Administrative Law Judge Folak described it, was for each of the respondents, their conduct, the level of culpability changed over time. It might be acceptable for Mr. Young, even knowing that SGC is financially dependent on SIB, an entity that's also owned by a single person, Robert Allen Stanford, and that both of them depend on a single product, the SIB CD. Maybe even knowing those facts maybe it was okay for him to just blindly accept that, well, someone's looked at these documents, it's okay. But as he learns more and more information, that simply becomes unreasonable and beyond the standard of care that would be appropriate for someone in the securities industry. And in fact, again, I believe the evidence would support a finding that it was reckless. Similarly, I'm sorry?
I hadn't even quite asked, right? But what's the evidence of reliance, and Mr. Young may address this in his rebuttal too, after Mr. Young began? In other words, obviously there's discussion, some of it under, I guess, the Howard analysis as well, of some prior advice given or assumption of prior advice given. But going forward, is there what is in the record of actual reliance, at that stage?
There's very little evidence of that. Mr. Young did describe a meeting that he had with Leroy King in Antigua. What is notable about that meeting, put it in context, that occurred at Alan Stanford's offices in Antigua. And given the importance of that relationship, given the information that Mr. Young had about allegations of corruption in Antigua, close connections Alan Stanford had with the government of Antigua, in some ways, that meeting should have been an additional red flag, much less something that's far from a reliance on that. And then as a legal matter on that, I mean, in some ways, that's also akin to someone in the United States saying that the SEC didn't bring an enforcement action, therefore everything must be okay. Now, Mr. King did make some representations about auditing and that sort of thing, but again, that's the only meeting that Mr. Young can describe, or at least described at trial about that. And then as far as advice on with conversations with counsel, there was an outside counsel who would have conversations with people at SGC. There was evidence about that. Of course, some of that came in the context of the fact that they were responding to investigative subpoenas from regulatory authorities. In fact, most of it came in that context. So it wasn't in the context of, there was no evidence of conversations where it was, are we allowed to sell this? What's, you know, and it was like that kind of thing. It was an understanding that outside counsel was involved in the process. But then again, that in some ways is an additional information that would support a finding of scienter, given that the multitude of regulatory bodies that were looking into SIB's CD, and yet, even in the face of that, it was continued blind reliance on the marketing materials.
Just quickly, could you distinguish Mr. Young's actions or inactions from cases like Huff and Howard, which he is stating, you know, in his brief, support his claim that he reasonably relied on others?
Sure. In those cases, there was information that was withheld from those people didn't have, and so they, of course, and didn't have the training to make that kind of determination, and so they relied on the professionals. But they knew the role of those professionals in those cases. Here, Mr. Young doesn't know what information has been given to them, doesn't know how kind of questions they've been asking, and also they're obviously very interested counsel that are involved in this case. This is counsel that represents SIB and Alan Stanford. It also represents SGC. There was no independent advice given in this case. And then also, I think that's the information that Mr. Young had in his possession that simply made it. He knows, for example, that maybe outside counsel said it was okay to have a brochure or have marketing materials that reference a well-diversified portfolio and that everything was liquid. But he knows that fact is untrue. He knows that SIB has private equity in its portfolio and not insignificant amounts of private equity. And so when someone in Mr. Young's position actually knows facts that are contrary to what's being told, I don't believe that the professional can excuse that. And certainly here, where Mr. Young never raised that with anyone, never asked the outside counsel, for example, wait, I see this, how's this? At least there's no evidence of that in the administrative proceeding. The last thing I just wanted to touch on was the sanctions that Administrative Law Judge Fulak imposed. I think they were more than supported by the record. In fact, once again, Mr. Young was given some leeway in this regard. For example, on the disgorgement, Administrative Law Judge Fulak only made him disgorge compensation that was tied to the sales CDs by SGC. But there was evidence in the record that SGC would have been defunct without the sale of CDs. So in some ways, without the CDs, Mr. Young doesn't get paid anything, and that those all his compensation could be disgorgeable. She took a more conservative approach, and the industry bar, given Mr. Young's conduct, seems more than warranted in this case. Thank you.
Thank you. Mr. Young, you may proceed with your rebuttal.
Before I begin my prepared remarks, I'd like to point out the fact that during trial, the staff was unable to produce one witness that testified that I trained him regarding the SIB product. Not one witness testified that I was even there at Stanford Group Company when they were trained. As I've previously stated, this case is a result of a perfect storm, never seen before, and hopefully happens only once in a lifetime. When else has there been a case when both the regulator and accountant were paid off and the Ponzi scheme lasted 10 years? Yet here we are, and both the staff and Judge Folick believe that I should have known. This, Commissioners, is a message case. What message are you sending to CCOs if you uphold Judge Folick's decision? To CCOs and other practitioners, the message is, Chair White, is that even though you, as an attorney, may be engaged as legal counsel, they, as CCO, are not allowed to rely on your representations if the SEC comes calling. In addition, if this case is upheld, Chair White, the message is that no one can rely on the statements that you make as chair of the SEC, or Commissioner Stein or Piwar either, for that matter. Mr. Reese tried to downplay the meeting that I had with Mr. King because it was in SIB's offices. Doesn't matter. He either told the truth or he lied. We now know that he lied. You wouldn't know it by reading Judge Folick's decision or the staff's request to my request for review, or the staff's response to my request for review, but we're not dealing with an unregulated offshore entity not required to issue annual audited financial statements. If that were the case, then I would probably agree with the staff that my not knowing what was in the portfolio could be problematic. What we are dealing with, however, is an offshore regulated entity with annual audited financial statements that were stated to be in compliance with international accounting standards. In this instance, reliance on audited financial statements issued by a duly qualified and vetted accountant and having a substantive conversation with the regulator relating to his oversight of the portfolio and his exam process, and being told that I can't see the portfolio because of Antiguan privacy laws by the regulator is not the same as not knowing what's in the bank's portfolio. My approach was not negligent in any way, shape, or form, but rather I investigated red flags such as the allegations of corruption, a one-man accounting firm, a foreign regulator, etc., and trusted the process. Is that not something CCOs should be afforded? If this decision is upheld, it will send the message to every CCO in the industry that they can't rely on any audited financial statements, and to every foreign regulatory authority, we will not recognize the sovereignty of your country or the legitimacy of your regulatory structure. Are these messages the Commission wants to send? What message does it send when an individual is engaged in 2004 to serve at the SEC's request as an independent distribution consultant? In 2006, when that individual informs the SEC that they'll be joining Stanford as the CCO, they ask the SEC if they have any specific concerns or would like him to resign as trustee. The very same SEC office he informs is working on a draft of a formal order against Stanford, but does not request the consultant's resignation as the trustee. And as a result, the individual serves as both an independent distribution consultant, ensuring the return of ill-gotten gains to investors, and at the same time is serving as a CCO and alleged to have committed securities fraud. The same individual continues to serve as trustee for an additional 15 months after the raid. And that same individual is served with a Wells notice by the same SEC office a month after the distribution is finalized, and he has completed his assignment as trustee. That individual, ladies and gentlemen, is me. The Commission has said over and over they are not after gotcha violations. However, this clearly appears to be a gotcha scenario where the staffer is permitted to use after-the-fact judgments and can discount or distort on-the-fly decisions made by a conscientious CCO acting in good faith with the information and knowledge he had at the time when he made his decisions. To the extent the initial decision is allowed to stand, the message you will be sending is clear. Despite everything the SEC has said about the role of being CCO, the first line of defense, the message will be, to the extent the deal goes south, CCOs will be standing in front of the firing squad. It doesn't matter if you, Mr. or Mrs. CCO, have been lied to by numerous touch points, including a regulator and an auditor, including the chief financial officer, including the chairman of the institution. When the media, politicians, or others, including the SEC, demand someone be crucified, it will be the CCO. Because that's what the initial decision does. It kills my career as a CCO, and it impugns my reputation in the industry, which I have so proudly served and been a part of for the last 30 years. This is also a message case about the administrative law judge process. Even though the Commission made the right steps in the right direction last fall, the process still failed in this instance. As I said before, in a typical ALJ proceeding, the respondent has access to his files, notes, computers, hard drives, and all other corporate documents at his disposal in order to prepare for his defense. In this case, however, the staff knew the receiver had all my records, as well as all other corporate records I may need to review for preparation for this case, but only provided me with documents of their choosing. To date, I have not seen my complete set of due diligence binders, my original handwritten notes, responses to other regulatory requests, or any other records other than what the staff has arbitrarily decided to provide me or my proxy at the warehouse thought might help. The SEC had my documents for 3.5 years after the raid before they instituted formal proceedings, and I was given significantly less time to prepare my defense without the benefit of a substantial percentage of my records. The staff has made a big deal about my hiding behind the Antiguan privacy laws. If you read the transcript of my testimony, however, you would see that I offered to review with them the 3 other Antiguan laws addressing privacy. But rather than take me up on my offer, they changed the line of questioning. Then they stated in their filings that I was unable to point to a particular law addressing privacy. This is just one example of the staff misquoting, distorting, and otherwise mischaracterizing my testimony, something they would be held accountable for in a court of law. If you read the transcripts and review the exhibits presented and compare them to the staff's positioning, you'll be amazed at the lengths they went to prove their case. But as in the administrative process, where you are the finder of fact, the authorizer of the complaint, the prosecutor, the judge, and the jury, where's the accountability? In fact, every single allegation that Mr. Reese talked about now is rebutted with transcripts and exhibits in my final briefing. If you uphold the ALJ's decision, you'll be sending the message that we, the SEC, can use the ALJ process to our benefit and our discretion because federal rules of evidence and other protections such as due diligence don't apply. Do you really want the ALJ process to be seen as a way to deny individuals due process and not allowing them the means to defend themselves? Yet that's exactly what happened here. In a speech in November 2013, you, Commissioner Pirouar, referred to the Commission's canon of ethics and stated, quote, to carefully guard against any infringement of constitutional rights, privileges, or immunities of those who are subject to regulation. You further state that we can not allow public outcry, agency morale, politics, or jurisdictional turf battles to be the reasons for pursuing or not pursuing enforcement action. An SEC attorney who participated in Mr. Reese's trial team told my team after the trial, we know there was no way Bernie could have known what was happening, but we had to bring the case. Commissioner Pirouar, how does that reconcile with your statements about the Wells process and about the lawyers remarking about it? How does that tie into what your remarks are about bringing cases? As mentioned earlier, the staff sent a letter to the Antiguan regulators in June of 2005. I provided a copy of that as an attachment to my request for review. Yet when the SEC posted my filings, the original filing in November of 2013 and the amended filing in December of 2013, the SEC unilaterally and arbitrarily redacted this attachment in its entirety. As a result, did not the staff attempt to conceal or mislead the public by arbitrarily posting whatever information they determined? The ALJ has found that I violated various statutes by willfully making misrepresentations, but yet the staff has apparently permitted to selectively disseminate respondents' information to the public in connection with the ALJ process by unilaterally redacting information provided by a respondent. And how does this unilateral redaction give the investing public and the industry an accurate portrayal of my defense? In October of 2014, I wrote the SEC and requested a status update on the case and an explanation as far as why the attachment was redacted. The response I received via phone from a staffer was that it was redacted for privacy concerns related to personally identifiable information. A review of the letter will show you and anyone else it contains no such information. Yet this open meeting today is held pursuant to the Sunshine Act when one of the exemptions available to hold a closed meeting is privacy concerns. Once again, it appears the SEC is selectively choosing how, when, and which form the information is disseminated. Ladies and gentlemen, commissioners, what we have here is a travesty of justice, and my request is very simple. I ask that you please set aside the ALJ's decision in its entirety and send the right message to the CCO community about what your expectations are, and send the right message to the industry about the integrity of the ALJ process. Thank you for your time and thoughtful consideration.
Thank you, Mr. Young. And thank everyone, Mr. Reese, for participating in today's proceeding. The commission will take the matter under advisement. We are adjourned. Thank you.
Thank you.